Welcome to today's webinar, Due Diligence Concerns When Buying a Building with Rent-Regulated Tenants. I'm Heather Stone, Executive Editor of the Habitat Group, which publishes New York Apartment Law Insider, the New York City Apartment Management Checklist, and the 2021 Rent Regulation Checklist. And that is written by today's speaker, Eileen O'Toole. And I will introduce Eileen in just a moment. First, I would like to thank the New York City Real Estate Expo for hosting this webinar and doing a fine series of webinars between big expo events. Also, I would like to say that today's webinar, we will have some slides, and you will receive a copy of the slides after the webinar. In the next day or two, we'll send you a PDF of the slides along with a link to the recording. Also, you may see that there's a Q&A section, but this webinar is only a half an hour, so we're probably not going to get to any questions. If you are dying to write us a question, we'll review it. We might not be able to get back to you, but feel free to give us suggestions for future topics for webinars. We really do appreciate that. Okay, I think I covered everything. Now, without further ado, I will introduce our speaker, Eileen O'Toole. Eileen is the principal of the law offices of Eileen O'Toole. She counsels owners, lenders, and prospective purchasers of residential properties on rent regulatory and other housing issues. She also appears before courts and DHCR in all phases of landlord-tenant litigation. She's the author of the 2021 New York Rent Regulation Checklist, a comprehensive guide to rent stabilization and rent control, published by the Habitat Group. Thank you, Eileen, for speaking with us today.
Thank you, Heather, and thank you to the NYC Real Estate Expo for sponsoring this webinar. Thank you, everyone, for being here. It's a beautiful day in the neighborhood, so I'm glad you decided to join us today. I am speaking about due diligence concerns when purchasing a residential property, which is a big topic, and I'm going to try to be a New York fast talker and get in as much as we can during the first half hour. As to the overview of what we'll try to cover today, in the next slide, show that, I'll talk about who needs to know, and what I'll focus on is the first question is the building I'm contemplating buying subject to rent stabilization, or could it be subject to rent stabilization? And sometimes what is presented at the outset from the seller's end may be incorrect. So there are things that you'd want to check out if you are the buyer of the building. And then after that, what becomes important if it looks like a building could be rent stabilized is whether there is exposure for potential claims of improper deregulation in the past or for rent overcharge. And toward the end, I will try to give you a list, they're in the slides, of some resources that you can help keep yourself informed with. So who needs to know about all this? Primarily purchasers of residential buildings. I'm focusing on New York City. There are areas outside New York City in the state of New York that are subject to rent stabilization, but we're focusing on New York City here. There are lenders that finance purchases of residential buildings. They may often know more than we do, since they are involved in a lot of transactions. Sellers also sometimes will do their own due diligence review before putting a property on the market, because sometimes a seller needs to identify potential issues. And transactional real estate attorneys. In New York, attorneys represent buyers and sellers of all kinds of property, and transactional attorneys may or may not be up on rent stabilization law. And I know that I and some other attorneys in this field who focus on rent regulatory matters actually sometimes get hired by some big firms to help out with transactions. So there's a lot of people who could use the information when it comes to the purchase and sale of rent regulated buildings. And one thing to keep in mind is even if it's a small building, generally rent stabilization covers older buildings that were constructed before 1947 or after 1947 up till 1974. And usually it's for buildings that have 6 or more units. Sometimes there are buildings with fewer than 6 units that are also subject to rent stabilization for various reasons I'll try to touch on. There also may be in buildings some rent control tenants that were in occupancy before June of 1971 or who have successor family members who have taken over the rent control tenancy and are still in there. There's a lot fewer rent control tenants today than rent stabilized tenants, but there are still some. So what in looking at initially, is this building that I'm contemplating buying subject to rent stabilization? There are variations on the theme, as I call it, that people need to look at. I'll touch on them in the next slide. So that, for example, the building, you're looking at a building and it has fewer than 6 units. So you may assume that you don't have to think about rent stabilization. But sometimes the building may be part of what's called a horizontal multiple dwelling. These typically were small buildings that were attached to each other, built in the 50s or early 60s, and they might have had a common boiler. They might have been on the same tax block. They might have had a common sewer system or tax filings or management and ownership. And later portions of the buildings were sold off. So today someone may be looking to buy a building with 2 or 3 apartments, and there start to be indications that there are rent registrations or there are rent stabilized tenants or rulings that there's rent stabilization. So that may be one thing to look into when you're buying a building. Another thing where you may have a building that has fewer than 6 units and is subject to stabilization is whether the number of units in a building was increased or decreased. If a building had 6 apartments in 1969 or 1974, when rent stabilization took effect, it was subject to rent stabilization. If the 6-unit building was later reduced to a 5-unit building, that did not remove the building from rent stabilization. And there are a lot of cases about this issue. It still comes up. There was a recent case that I wrote up for the landlord versus tenant case digest newsletter. And it works the other way too. If your building, when rent stabilization went into effect, had only 5 apartments and therefore was not subject to rent stabilization, and later an owner divided the building so that you had more apartments, you converted the building from 5 units to 6 units, then you become subject to rent stabilization. And people sometimes don't realize this, and then it becomes a problem later on when there starts to be litigation over whether the building is rent stabilized. Sometimes a building gets substantially rehabilitated, replacement of a lot of the interior of the building, about 75% of all the building and apartment systems. And that removes a building from rent stabilization permanently, unless the owner took a J51 tax benefit when doing the substantial rehab that would keep the building under rent stabilization. And sometimes there may be a presumption that a building was substantially rehabbed, but there's never been a court or DHCR ruling on the question. And so that leaves it open to perhaps a tenant raising the issue in the middle of an eviction proceeding, and then there would have to be a determination. The tax benefit programs, I mentioned J51, there's also the 421A program that's for new construction after 1974. If an owner gets the tax benefit program for that, and those buildings remain subject to rent stabilization also for a period of time. There may also be, more in the outer boroughs than in Manhattan. You have 1 and 2 family houses, or maybe 3 family houses, but you have 1 and 2 family houses that sometimes the owners divide up into SRO units, into a rooming house or into a number of apartments. And aside from that being a housing code violation that the owners can get fined for, the creation or division of a house, a 1 family or 2 family, into a number of units could expose the owner of the building to a claim that the building is rent stabilized. So that's sort of a summary of some of the building concerns, but then there are other things to look at concerning individual apartments. During the period where vacancy deregulation was permitted, or luxury deregulation for existing tenants, which has now been abolished by the HSTPA, apartments that were lawfully deregulated before June 14th, 2019 remain deregulated. But whether or not they were lawfully deregulated is something that can be challenged at any time, even now. So that's something I'll talk a little bit more as we go ahead with this, but that's something that one has to be concerned about, because sometimes what's presented in the marketing of a building is that it has 20 deregulated apartments and 10 rent stabilized apartments. And when you start looking at the documents, there may actually be questions about the deregulation. Another thing that you have to consider is whether there are some old outstanding DHCR rent reduction orders that have frozen the rent for 20 years, but no one's paid attention to those, and they still are in effect and have to be dealt with. There also are situations where you have individual apartments that are temporarily exempt from rent stabilization because the owner lives in them, or a super who does not pay rent lives in the apartment as an employee, and those apartments would become subject to rent stabilization again once those people leave, which is often the case when the building is sold. So, a buyer has to be concerned about what is going to happen with the rent when those apartments become vacant. So that kind of brings me to the point of what is a buyer looking for documentation wise when considering a purchase, and what are they entitled to ask for, whether they get it or not. The first thing you usually see is the seller's rent roll, which will show the current rents, the apartments, the tenant names, whether they're subject to stabilization or not, and the total rental income monthly. Sometimes the seller's rent roll will also indicate whether a tenant is receiving Section 8 benefits or receiving SCREE benefits that freeze the rent, and with SCREE, the owner gets compensation from the city for participating in the program. But then the first thing I usually like to see is the DHCR rent roll. That's the DHCR summary of annual rent registrations. This is not public information. The seller may have a copy of it that the seller can provide to the buyer, or the seller gives the buyer authorization to get that information from DHCR. And that will show you whether the building's been registered since 1984. It will show you if at some point apartments were registered as vacancy deregulated and then were no longer registered. And it will show you, sometimes it will show you if there are any things that look odd or need to be checked out. What you get usually in conjunction with what they call the DHCR rent roll is a cases by building report. And that is a summary of any applications or complaints that were ever filed with DHCR. It goes back to rent control days with the information. And it's just a summary. It gives you a docket number. It gives you a date the complaint or application was filed. It gives you the outcome of the disposition, or lets you know if the case is still open. It'll show you if there was a rent reduction order that I mentioned earlier, 5 years ago or 20 years ago, and then there was never a corresponding rent restoration order afterwards that tells you there's an issue with the rents there. Other documentation that you may want to look at that may tell you some things about rent regulatory issues. HPD has a multiple dwelling registration page online. It'll show you if the building is registered with HPD, if it has 3 or more units and is a multiple dwelling, it should be. And there may be indications on that page if there's any open certificate of no harassment application, which is something that is filed if an owner wants to do construction work at a building that has SRO units or is in a special district identified by HPD. And that information, and you can't do the work until you get a certificate that there's been no harassment of tenants from HPD. And there's usually some indication on the webpage if there's anything pending in relation to that. Another thing, if you're looking into whether a building was substantially rehabbed or whether it was changed from 6 units to 5 units or 5 units to 6 units at some point, the Department of Buildings has a lot of information. You can see if a building has certificates of occupancy. You can see jobs filings, records of whether permits were obtained, and look at that information if it helps to fill in the blanks where there are some questions. The Department of Finance website used to be a really good place to look for information about J51 status of a building and what years a building had J51 and when it began and ended. And a few years ago, the website was changed somewhat and there was more limited information. So that may take a little more digging to find out if it's not reported to you by the seller outright, whether there is any J51 or 421A application pending. Important documentation, if it looks like you have rent stabilized tenancies or you're concerned that you may someday have to defend against a claim of improper deregulation, are all available leases. Sometimes there are people who buy buildings that have no leases. Sometimes there are sellers who have leases going back 20 years. There's a real range of difference there. And if the records are not available, it doesn't necessarily mean you don't want to buy a building, but it may mean that you are taking more risk and may be something that results in negotiation on the price. DHCR has, not DHCR, the state has amended the rent stabilization law to now require 6 years of information at least, rather than 4, if a tenant files a complaint of rent overcharge in order to determine the rent overcharge. And if there's a question about whether the building was properly deregulated, you would have to produce documents for an apartment going back even further. So it's important to get all available leases. If there aren't leases or aren't many leases, you may also want to get copies as an alternative of rent ledgers. A lot of owners and management companies keep rent ledgers on the computer anymore. So getting copies of those records can also be helpful. I'll talk a little bit more about IAI's individual apartment improvements in a few minutes, but records of any improvements to the apartment are important to have at this point, because that's often the sticking point about whether rent increases were properly collected for an apartment. I also mentioned at the end here, any regulatory agreements. I won't really go into that, but there are buildings that are initially regulated, through HUD or NYCHA or some other program, and then or HPD, and when it comes toward the end of those programs, the buildings become rent stabilized. So if you're looking at buildings that have any of those kind of agreements, it's important to understand what they are. Okay, so you get all this information, and what's it going to tell you? On the next slide, it may tell you, are the apartments rent stabilized, and is there any rent overcharge exposure? Those are the two big questions for rent regulation. In the next slide, I indicate a couple of recent cases, and I've been talking about this. There's 2 separate questions are apartments properly deregulated if a seller says they are vacancy deregulated or high rent deregulated, or are they actually rent stabilized? And that's a separate question from whether there's a rent overcharge. If there is a question raised by DHCR or a tenant as to whether an apartment was properly deregulated, DHCR or a court, whoever's reviewing the question, can look back well before the 4-year statute of limitations or now the 6-year statute of limitations to determine that question. And generally what the owner would have to produce is a copy of the last rent stabilized lease, a copy of the first deregulated lease. If there's a notice to the first deregulated tenant that they're being deregulated, there's often lines in that are filled out that show what the increase was based on. A lot of times that's where individual apartment improvements come in, and it'll say how much was spent on individual apartment improvements or how much of a rent increase was taken, and the owner's going to have to be able to document that. The appellate division, the first department, just recently had one of these cases that again said you can go back as far as you need to DHCR or court to determine whether the deregulation was proper. And then DHCR turned around very quickly last month and had one of its own cases where it cited this AEJ 534 case, and again reiterated, which they have in the past, that you have to produce the documentation to prove you're deregulated, or they will find that you are rent stabilized. So then what happens then? What one has to consider when thinking about buying a building that has rent stabilized apartments or may have rent stabilized apartments is whether there's a rent overcharge and whether anything has been done about that or can be done about that before purchase, or are you as the buyer just taking on the obligation. Generally, under the law, the buyer steps into the shoes of the seller and takes over liability for potential overcharge exposure. I think it's very unusual to have a purchase and sale agreement where the seller agrees to cover the expense if there is a future overcharge finding. What I've tried to do here, I probably won't go through them all because just as to keep track of the time here, but I've summarized in the slides what the factors are in the law for looking at rent overcharge liability. It has to do with treble damages. It has to go with how far the look back period is. It has to go to whether the complaint was filed before or after June 14th, 2019 with the HSTPA. Treble damages are much more extensive than they used to be. It used to go back 2 years, now they go back 6 years. Attorney's fees can be awarded. Well, they always could be awarded, but now they shall be awarded to a tenant if there was an overcharge finding and there was an attorney involved. And tenants have the right to raise the claim about rent overcharge in either court or before the DHCR, which was always true, but a lot of times the courts used to bounce the questions over to the DHCR, which made everybody unhappy. And now the law says, no, if you bring the complaint before a court, it can stay before a court, which probably only makes the court unhappy. So that's kind of the basic things to be concerned about with rent overcharge. And what I've tried to summarize in the next couple of slides are the rules for, well, I talk about, a lot of times a buyer will try to do or have assistance from someone who may know how to do it, is calculate what could the rent overcharge exposure be, worst case scenario. And there has been a lot of case law in recent years where it hasn't been clear. There have been different standards posed by different courts and DHCR. One thing, the Regina Metropolitan case in 2020, the Court of Appeals case determined was that if you have the base rent information, that becomes the starting point for calculation of rent overcharges beyond that point. And sometimes you don't have that information. And in that case, DHCR may use a default formula, which is either, there's a few different factors. They pick the lowest one, either lowest comparable rent for a similar apartment in the building, or the rent, the last rent minus a guideline increase. And they will figure out the rent that way. And then there's always the question of fraud, which has been another element thrown into the mix. If there is some indication that the rent was fraudulently set to get it out of rent stabilization, then an overcharge calculation can go back further than the base date to figure that out. So it can get complicated, and it is something, that's the area where a lot of buyers may be interested in, or maybe should consider getting assistance from, an attorney or an accountant to help figure that out. So what I have then tried to do here is summarize what the key points are for calculating rent increases for individual apartment improvements. The rules on this issue changed a lot in 2019 when HSTPA amended the rent stabilization law. The amount of rent increase that could be collected for IAI improvements used to be unlimited. Now it is very limited. It's just $15,000 over a 15-year period. The percentage increases are quite low, and it is considered a temporary increase for a 30-year period rather than a permanent rent increase. So do I have anything else to say about IAIs? That's the point of giving you this information, is just to point out how important it is to get from a seller, if the information exists, copies of any contracts for doing the work, copies of invoices for the work, copies of canceled checks. If something was paid for in cash, there have been cases where DHCR has asked to see the bank records to show the transfer of the cash. Photographs are important. And on top of all this, DHCR has established, as of last year, a centralized electronic reporting and recording system for tracking IAIs, and it's part of the information that now has to be registered with the apartments. So DHCR is watching you, and sometimes initiates its own audits of that information. The DHCR riders that are supposed to be attached to leases also give information to tenants that says that they are permitted to request the IAI documentation from an owner within 60 days of getting a vacancy lease. So, and I will say that all of this, a lot of the things I talk about here in the brief time we've had together are topics that are in the rent regulation checklist, which, I wrote the first edition of it several years ago, and Habitat has let me update it every year so far because there have been enough changes to the law. And I think I originally wrote this book with my primary reader in mind was myself. It was something to help me look things up that had to do with rent stabilization issues. I've given you a list here. DHCR webpage has a lot of fact sheets, policy statements, operational bulletins, all giving you further guidelines about the different things we've talked about here today. Something we didn't talk about was the eviction moratorium and what's going on with housing court. If you look at the New York Unified Court System webpage, that keeps pretty up to date. There's a weekly update from Judge Fiore, and there's a lot of information on those web pages. There are some other government resources, and Habitat Group has a lot of publications. The Apartment Law Insider, the monthly Landlord versus Tenant Digest that I also write for them, and the Apartment Management Checklist is helpful. There are owner organizations out there that also provide useful monthly newsletters and weekly updates, CHIP, RSA, organizations like this, the New York City Real Estate Expo, which is doing a lot of educational seminars now, even outside of their expo dates. And it looks like in the future, the New York City Real Estate Expo is going to start having some live, maybe in the fall, we'll have live expos, or go back to live and Zoom, who knows. So
Everything will be hybrid, live.
Hybrid, we'll all be hybrid from this day on. So anyway, thank you all for listening, and yes, submit any questions that we may try to answer. And
yes, thank you, Eileen. And yes, we'll be sending out a copy of the slides as well as a link to the recording in the next day or two. But thank you all for attending, and thank you, Eileen and Anthony from the Real Estate Expo.
Yeah, thank you, Heather. Thank you, Eileen. And yes, everybody will receive a copy of the video as well as the slides. I will also include the information how to contact Heather at the Habitat group, which I recommend you all doing, and learning about becoming a member and also subscribing to their information. It's extremely so important, so informative, and especially when you have people like Eileen giving us her thoughts and her advice about a lot of this important stuff that's going on, especially today. I know that you guys are going to be participating at our expo. Do you have like a little idea as to what topic you might be talking about, Eileen?
one possibility, if it happens, is that after the rent stabilization law was broadly amended in 2019, the law said that DHCR was supposed to issue regulations, amendments to the rent stabilization code by June of 2020. That still has not happened, probably because of COVID and the government agencies shutdowns for a period of time. So between now and the fall, there could be issuance of the rent stabilization code. It could be expansive. That could be a topic that would be of interest to a lot of people. And if that hasn't happened, I'm sure we will come up with something else. There's always a lot happening in the area of rent regulation.
That's great. Once we post that, once we put it out there to market it and start marketing your topic for the expo, if anybody should have any questions, please, we don't want you to wait for November. Submit your questions into Eileen, and I will connect you with Heather and Eileen during this period from now to November. So once again, guys, thank you so much. I really appreciate it. I'm sure the audience appreciate it. And we can't wait for your next topic. And of course, I know you're going to have a topic for the expo, but maybe before the expo, you'll submit a new topic for us. Okay. Thanks again, everybody. Thanks, Eileen.
Thank you
Thanks
very
all the
much.
attendees.
Thank you. Bye-bye, everybody.
Bye-bye.
Bye-bye, everybody.